Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. If you find this podcast helpful, please recommend it to a colleague.
And a quick thank you to our sponsor. Our podcast is sponsored by CaseText. CaseText is a legal research tool that harnesses AI and a lightning fast interface to help lawyers find case authority fast. I've been a subscriber since 2019. I highly endorse the service. And listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
Today on the podcast, we are honored to welcome Justice John Zebrowski to the show. For the past 23 years since retiring from the Court of Appeal, Justice Zebrowski has held down a full-time arbitration and mediation practice focusing on all manner of corporate and business-related disputes. Justice Zebrowski is an alumnus of the University of Pennsylvania and Georgetown Law. After several years in private practice, Justice Zebrowski had joined the Los Angeles Superior Court as a commissioner from 1982 to 1986, and he was appointed to the bench in 1986. And then in 1995, then Governor Pete Wilson made Judge Zebrowski into Justice Zebrowski, who then retired from the bench in 1999 to join ADR services. But as we'll discuss further, that was not the end of Justice Zebrowski's service in shaping California law. Justice Zebrowski, welcome to the podcast. Thanks for joining us today.
Thank you.
Now, Justice Zebrowski, I read that you are a Western Pennsylvania native and the son of a factory foreman and a waitress. What was the path from there to the California Court of Appeal?
Well, it was like things that happen in life where you get a little bit of luck and a little bit of help at the same time and things work out. This was a situation where when I was in high school, one of my high school track coaches was acquainted with an alumnus from the University of Pennsylvania, and this alumnus happened to be interested in the track team. And so my coach arranged for me to meet this alumnus, and the alumnus arranged for me to meet the track coach from Penn. And one thing led to another, and I was offered a scholarship to go to Penn. Not 100%, unfortunately. I still had to supplement that with a little bit of side work, but it made it possible for me to attend Penn. So there I was attending Penn then. Once I graduated from Penn, I worked for a couple of years and then applied to Georgetown, went to Georgetown. And when I graduated from Georgetown, I came out to work for a firm here in Los Angeles that has since been merged out of existence, the old McCutcheon firm. But I worked there for a while, and then I was given this opportunity to join the Superior Court, and I did join the Superior Court, and then from there it went, as you said in your intro a little while ago.
I also heard that you had done spent some years working in steel mills. Now, being from Western Pennsylvania, that it's a common profession or common job out in those parts. So I take it that was that a career in law was not a straight trajectory. You had your path led you through the steel mills, and as you mentioned, track and field, scholarship, supplementing your income in other ways. Tell us about your experience working in the steel mills and how that informed your later work as an attorney.
Well, I worked in the steel mills during the time of my college undergrad career. I worked in the steel mills about 16 months in order to supplement the money that I had from the scholarship, so I could afford to go to Penn. But before I got to working in the steel mills, I had worked in other places too. Truck loading docks, construction work, dairy plant, things of that nature. But working in the steel mills illustrated to me the danger of working in heavy industry like that. I mean, people really do get injured in jobs of that kind. And when I was there, that was prior to the Occupational Safety and Health Act. So things were a little more dangerous then than they are now, hopefully. But it was quite an experience to see how people worked and what risks they would take just to bring home a few dollars of pay.
And was a career in the law always part of your career objectives, or did that only dawn on you at a later time?
I always had an interest in it, but it was really in my undergrad time that I decided I would go to law school. So I can't say I was planning it from kindergarten. It was something that came up later on when I started deciding what I was going to do that was not going to be working in a steel mill.
Right. Well, Justice Zebrowski, while you have not served on the bench in a couple of decades, still in that time since you retired from the bench in 1999, you have served in a number of other important roles affecting law and legal practice. And I'd like to just touch on a few of those with you. First, you served on the Law Revision Commission. You were appointed by Governor Schwarzenegger to the Law Revision Commission in 2008, where you served as chair in 2010. What can you tell us about the role of the work that you do in the Law Revision Commission for our listeners who are not familiar with its impact on shaping California law?
Well, the Law Revision Commission is designed to assist the legislature in maintaining the statutory law of California in good shape, where there's not ambiguity, there's not mistypes, there's not things missing there. It's the work of the Law Revision Commission is to assist the legislature, but it's in a very technical way. It's not policy discussion. We're not the ones that the legislature comes to decide what the policy content of the statutes should be. We're the ones to make sure that they make sense. Like, for example, one of the projects we did was to take all the references to firearms that appear in the California statutes and make sure that they are all those terms are clearly used. And we found things like, for example, there would be one concept that would have 3 different labels attached to it, even though it looked like they meant to say the same thing each time. They used 3 different words or phrases to refer to those topics. And as you know, when you're doing a statutory construction, one of the things you look for is a different word being used. And if a different word is used, there's a presumption that it's because the legislature wanted it to mean something different. But the Law Revision Commission would do its work and conclude it really appears that the legislature meant to say the same thing here, but they were doing it at a different time in a different place with different personnel involved and so forth. And so they used a different term to refer to that very same concept. So our report then would contain a recommendation that this be looked at and to see whether we should have this amended so that it would all be one term and not lead to ambiguities. So those are the type of things that it would do. And I think the people at California are getting a good bargain from the work of the Law Revision Commission. It's very small, but it has some very good staff people, and they do a lot of hard work.
I wonder if it gets difficult finding folks to serve in a role that does not. You said that the Law Revision Commission does not concern itself with matters of policy. Is it difficult to separate the two, because those kind of things everything always tends to bleed into policy? I'm thinking of a recent discussion Jeff and I had about a recent Ninth Circuit opinion where Judge BAJI filed a separate opinion about the use of the term non-citizen used in the majority opinion, where the statute uses the word alien, and the majority had reasoned that alien could be deemed to be a derogatory or offensive term, and decided to opt for the term non-citizen instead. And Judge BAJI said that makes things difficult for the litigants who have to use the statute and its term alien, and then the judges who apparently now don't like the statutory term. So all things pedantic and definitional eventually become a matter of policy. It's only a matter of when. It sometimes seems. I wonder if it becomes if you ever had an experience where it was difficult to find that line in between what's policy and what's merely mechanical or definitional.
I didn't really find that on my work with the Law Revision Commission, although we would at times have discussions about whether the use of a particular term or phrase presents a question of policy. And if we were to determine that it did present a question of policy, we would then decide that we'll just tell the legislature that it looks to us like this implicates a question of policy, and therefore we're moving on past it. But if we're wrong about that, let us know, and we'll do a study of it and give you a supplemental report. But
are there different philosophies or schools of thought represented among the different commission members?
I didn't find that to be the case for this type of work. This type of work is really law technician work. just trying to find out, if these two words, non-citizen and alien, are used, is that because they mean different things, or is that because they were put in at different times by different people and maybe they should be harmonized?
Right. And how many members are there on the Law Revision Commission?
That's a good question. It's been a long time now since I was on the Law Revision Commission, but if my memory serves me, I'd say it's about a dozen.
Okay.
There's a mixture of people in private practice and people in government practice and people from some of the prosecutorial offices and people that work for the legislature, and get a good mix of people.
Yeah. You also served on the State Bar Liz Pendens Committee, where you drafted code commentary that now appears in the annotated code. In my anecdotal experience, too many lawyers, both practitioners and judges, don't seem to understand what a Liz Pendens is and when you may record one. What is the role of the Liz Pendens Committee, and what was your experience serving on it?
Well, that was a sort of a unique situation. There was a Liz Pendens law that was in effect until about 20 or 25 years ago, the time when this law that's now in effect went into effect. And that law, if you read it, it appeared to call for a factual review of the Liz Pendens to determine whether it was valid or not. But the Supreme Court came up with a decision saying that you cannot consider the facts on a motion to expunge a Liz Pendens. So this meant that the Liz Pendens would stay on encumbering the property up until the time of at least the end of appellate procedures, and it will cause a lot of mischief. And the mischief is being caused in a situation in which the law, as being applied by the Supreme Court case, was exactly 180 degrees of precise opposite of what the statute said. So I wrote an article about this. Was published in the magazine of the Los Angeles Bar Association, pointing out that we have the statute saying one thing and we have the case saying another thing. And so that created some interest, and so the State Bar formed what they somewhat grandiosely called the Liz Pendens Task Force. So they had this, basically it was a committee, but they called it the Liz Pendens Task Force, and they asked me to join it, and the job given to the task force was to come up with a new Liz Pendens law. And so that's what we did. We came up with that new Liz Pendens law that is in the books now. And then we presented it to the legislature and they passed it.
So he's the reason we have to take a writ up instead of an appeal on a motion to expunge Liz Pendens.
Well, there are a lot of things that were changed. I mean, now you can get a review of the facts, and if the facts don't support a Liz Pendens, for example, maybe you have to post a bond or something. But it made a lot of what we regarded as improvements to the law. And I have to say I haven't really been following Liz Pendens matters too much in recent years, because it's not the kind of thing that would come up in an ADR setting very much. You need a unique circumstance to come up with a Liz Pendens question, maybe in a malpractice case or something like that. But it seems to have been weathering the test of time pretty well.
Well, that's an encouraging case study. So you spotted a problem. In this case, it was a deviation between the statute and what the California Supreme Court said concerning Liz Pendens, wrote an article about it. The Los Angeles County Bar Association took interest in it, created this task force, and then lo and behold, we got a legislative change out of it.
Well, it was it was a state bar, not the LA County Bar. The article got published in the magazine of the county bar, but the state bar is the bar that got interested in it. And all that was done by people who were active in the real estate section of the state bar. And then I got asked to join after this task force had been assembled.
So is that a viable blueprint for other practitioners or judges, former judges who may see some friction in the law, some room for improvement, is to start with an article, see if you can get the attention of the state bar or one of its practice groups?
Well, I haven't seen it happen in any other circumstances, and I think you have to have a unique circumstance to have it work. But this was a situation where it was pretty obvious that the statute said one thing and the case said 180 degrees the opposite. And so it was an outlier that just was causing problems.
And was it the fact that it was causing problems the real impetus for affecting that change, or was it merely just the academic fact that people don't like it when statute says one thing and the Supreme Court says another thing? Or do you have to actually have the prejudice like we like to talk about in the appellate world?
Well, I would say all of that. At the time, around the time that I wrote that article, I was serving in the old writs and receivers departments in the Superior Court. So I was getting these pendens cases one after another. And I'd look at it and I'd see, well, the way the statute's written, this doesn't support a lis pendens, but the way the case is written, it does. And so I'd have to be making these decisions and explaining to the attorneys why I'm making this decision that's contrary to the wording of the, because I'm in lower court, so I have to follow the ruling of the upper court. So I have to follow what the Supreme Court says, and I have to explain to the attorneys why I'm making this ruling that is contrary to the plain language of the statute.
Right. No, we've to go off on somewhat related tangent. We've talked about this problem of Rule 8.1115, the rule that says that practitioners may not cite an unpublished opinion for any reason. We talked about this problem in the sense that the way that the rule is drafted is so broad that practitioners are actually forbidden by the text of the rule from citing an unpublished decision, even in a petition for review to the Supreme Court, on the grounds that there is a divergence of opinions. So you can say that there's a divergence of opinions, but technically under Rule 8.1115, you're not allowed to cite which of the unpublished diverging opinions exist. And I thought and of course the practice is that litigants will still cite to the unpublished opinions, and the Supreme Court seems to sanction it, seems to bless it as an accepted practice. But there you have some friction between the way that the Supreme Court actually practices and the litigants before the Supreme Court actually practice, and what the rule says. I wonder if you can comment on that, either as another example of friction that needs to be addressed, or just on the topic of unpublished opinions generally.
Well, we see a lot of citation of unpublished opinions in ADR work because the way the rule is drafted, it doesn't appear to rule out the citing of an unpublished opinion, say in an arbitration. And in any event, people will cite them quite frequently. But now you have to ask yourself, how did this situation arise where we have this opinion, but yet it's unpublished? Now, we know what the rules say about if it breaks new ground, if it shows a new way of the laws applied, you're supposed to publish it. But yet we'll see these unpublished opinions come down. Now, a lot of times, the reason why an opinion is unpublished is you have to put yourself in the shoes of the appellate justice. The appellate justice sitting there, he has his case. The case has to be decided. The appellate justice can't say, well, we're just not going to decide this is too close, or we don't think it's properly presented, or whatever. You have to decide it somehow. But of course, you may not have complete confidence in the briefing that you got. You may not have complete confidence in the way the cases have been presented, but you have to decide the case. So what do? You decide the case the best you can, and then you don't publish it. Now, the reason you don't publish it is so it won't be cited, because you're not confident that it's right. So when you're dealing with an unpublished decision, it's not like it's... I talk to a lot of law professors about this, and they just think everything should be published because it's more things for a law professor to play with, I think. But you can imagine what that would do to practice if we expanded the number of published opinions by a factor of about 10 or 15. And you'd have to read through 10 or 15 times as many case reports as you do now in order to present your papers. So if you see a case that's not cited, not published, there's usually a good reason why it's not published.
Well, and you just mentioned one of the reasons is because there's just an enormous amount of effort that has to go into writing an opinion to begin with, and then if you're going to make it a publishable quality, so that
right.
Let's say if you have a case that the facts are subtle and it could kind of go either way, but you get the panel deciding that it should go that it should be affirmed rather than reversed, but it's a close call, and you don't want it to be an example that could be cited as a definitive, unequivocal case of why all such cases should go that direction. Then you want to just make it unpublished so it doesn't become a problematic precedent. So I want I wanted to ask you if money and time were no object, and you could justices could invest as much time as was needed into making the holding as crystal clear as possible, so that it could be used as citable published authority. Would we still have a need for 8.1115, or there's the other cynical explanation for that appellate justices sometimes use unpublished cases is to kind of sweep cases under the rug, that if the case should come out one direction, but that maybe there's not good legal authority to support the outcome the way the panel wants it to come out, then they'll just stamp unpublished on it and be on their way.
Yeah, well, I'm not going to accuse anybody, but I will say I've seen some of these unpublished opinions coming through in arbitrations, for example, and it's hard to imagine how somebody could write this opinion and then have it unpublished. I mean, like, for example, the statute that says that when you're selling a house, you have to disclose all known defects. Well, it says known defects, but I've seen several cases in appellate in arbitration practices where the finding of the court was that the duty to disclose extends to not only known defects, but defects you should have known. In other words, to a negligence test. Well, that's quite a different ballgame there. If they're going to say that you're subject to an obligation to disclose things that you should have known, but which you didn't, so you can't disclose it because you didn't know it, then I should. Yeah.
So the published cases hold that sellers have to disclose known defects, but there are some unpublished cases that will say known or should have known, but they're not published.
Right.
And they just kind of exist in that uncitable periphery of the law.
Or sometimes you'll get a situation like, I mean, the justice has a lot of things to do. There are other cases that tend to. They're drafting an opinion. They look at it and they say, well, the attorneys that are actually handling this case, they'll know what I'm talking about because they've been handling this now for two or 3 years. So they know what this case is about. So I don't have to spend that extra 20 hours polishing the explanation here so that a person that walks in off the street completely cold, never saw this case before, can read it and be clear about it. So they'll issue the opinion in unpublished form because they're not worried about somebody misunderstanding it and getting led off down a rabbit hole somewhere.
And one other question about unpublished opinions in arbitration practice. Now, Rule 8.1115 doesn't apply to arbitration, so the rule doesn't prohibit practitioners from citing unpublished opinions in arbitration, which is why you mentioned that you've seen so many of them cited before you as an arbitrator. But notwithstanding the fact that they may, consistent with Rule 8.1115, cite that practitioners may cite unpublished decisions to you as an arbitrator, do you find that it's appropriate? Do you welcome citation of unpublished opinion, or do you get the sense that you oughtn't do that?
I wouldn't say I object to it being done, but I look at them with a skeptical eye. Let's put it that way, because if it's an opinion that's dealing with a well-established point of law, you ought to be able to cite me the published opinion on that. So there's a reason why it's unpublished, and it could be unpublished maybe just because it's cumulative to other cases that are published. But then, as I said, you can always cite me the published case then. So the implication is it's not standing for the published opinion theory, but for some reason it's not published, even though it seems to conflict with that. So why is it not published?
Yeah, so if you see an unpublished opinion cited to you as an arbitrator, you're probably thinking, okay, this either ought to confirm some published authority, or if not, we must be talking about some area of law that is unclear. This is a matter of first impression.
Yeah, so it could have been one of these situations where it's not being explained clearly in the unpublished opinion because the attorneys will know what the case is about, and it's not a good use of money and resources. And there could be a lot of reasons like that why it's unpublished.
Yeah.
So you're opening up a whole new panoply of considerations. And now, instead of trying to resolve the cases before you, you're thinking, why was this case not published? Well, that's kind of an irrelevancy if you don't get into it.
as a former appellate justice, do you think you see that issue differently than other arbitrators who have not served on the Court of Appeal, or do all arbitrators kind of understand that to put an asterisk next to the citation of an unpublished opinion?
That's a good question. I never really saw whether the people who've had the experience of serving as an appellate justice look at that differently.
All right, one of your other experiences I wanted to ask you about before we move on to talking about your experience as a neutral. You served on the BAJI Committee, which prepares the civil jury instructions from 2005 up until the present. Earlier this year, we had a discussion with another appellate attorney, colleague of ours, Stephen Love, and we discussed some studies showing that jury instructions just go in one ear and out the other of most jurors, and that just the absorbency rate of jury instructions is effectively zero. I wanted to ask you the same question as I asked Mr. Love: is the practice of reading jury instructions to the jury merely ceremonial? But first, I wanted to, just by introduction, ask you, what does the BAJI Commission do?
The BAJI Committee has been in existence for something like 60 or 70 years, a long time. And it, as you mentioned, kept current the BAJI instructions. Now, the BAJI instructions have, to a certain extent, not technically, but in practical effect, been to an extent superseded by the CACI instructions. But the BAJI instructions are still being maintained. And so there's a committee of about half a dozen of us that meet usually once every 6 months and go over any new cases that have come up that impact upon jury instructions. And we update the BAJI instructions, and West still sells them and people buy them and use them a lot, particularly in federal court. And so they're still alive and kicking, although I don't know if they'll outlast CACI, because CACI has the support of the Judicial Council and so on.
And yeah, so what is the, you said that the BAJI is more often used in federal courts, but CACI has the blessing, sanction of the California Judicial Commission.
I don't know if I would say more often, but I would say that often I see them in federal court.
Yeah. So what is the future?
The main difference seems to be that the CACI instructions were created with the concept of trying to make the instructions more understandable to the average person. So that's the whole point of CACI. They changed the syntax of the sentences and try to make it more understandable, which is a laudable goal, of course. Unfortunately, one of the things that can happen is if you're trying to simplify something, you can just leave some things out and it'll be simpler, but it will also be wrong. And so that's the risk that is posed by taking the CACI approach. Now, on the BAJI side, it's been around for a long time, and the criticism of the BAJI is that sometimes the technical language that gets into the instruction is a little much for a juror to understand. So the BAJI is subject to that criticism. So there's in different cases, you might want to use different set of instructions.
And do you have a perspective on the question of what impact does reading jury instructions to actual jurors have on the outcome of a case? Now, but as attorneys, Jeff, in my experience with jury instructions is probably when we're drafting a complaint, we'll look at the jury instructions to make sure we have the elements right. And then when we're preparing our opening statements and closing arguments, or consulting on as embedded appellate counsel for the trial team, we want to make sure that we're hitting all of the ultimate facts to establish our causes of action or affirmative defenses. And then obviously the judge wants to read the correct jury instructions so that on potential appellate review, there's no jury instructional error. But that the critical moment is when the judge reads the jury instructions to the jury, and we assume, rightly or wrongly, that the jury is understanding them, and then actually applying the facts to those jury instructions. But like you mentioned, sometimes the jury instructions are complicated. Maybe we can make them simpler, but maybe there's no denominator too small and common that is enough for 12 jurors to all understand what the law actually is. So what's your impression of is reading instructions to a jury merely ceremonial?
I think it's largely ceremonial. I think you're right that the jury doesn't absorb too much of what is read to them. That's why back when I was in a trial department in the mid 80s and computers were just coming out. This is back in the days of the IBM desktops and the Korean knockoffs and all that. I got myself a Korean computer, and I started preparing my instructions on because they used to be written out on forms and interlineation, and looked like chicken scratching a lot of times. You'd get a form and you'd scratch things out and write things. It'd be kind of a mess. So I started writing out my jury instructions on a computer, and then I would print out copies so that every member of the jury had their own copy of the jury instructions. And then we would have to read them because the law requires you to read them. And I would explain to the jury, we have to read them, but you're going to get your own copy and get to keep this copy. And anytime you want to refer to it in the course of this litigation, you can refer to it. And I think that they absorb a lot more of it when they have their own jury instruction, a set of jury instructions. Reading it to them, I think you're right, doesn't do much good. But it does the one thing, I guess, that the court reporter takes it down and you now have a record that these are in fact the jury instructions that were read to the jury. You would think it'd be easy enough to put an exhibit sticker on it and put it back to the file with an sticker on it, but maybe people don't trust that system. But of course, if you don't trust it for jury instructions, you probably should not be real trusting about other things as well. But
right.
In the event, reading it, their eyes just glaze over and it doesn't get them anywhere. But I found that when they have their own set of instructions, they read them like they're reading through the Bible and looking for great truth in there.
And yet I don't, is that a common practice? And if not, should it be a common practice handing the jury instructions?
I assume that's common practice now because I was able to start doing it back around 1984 or 5 and all the way up through there. Of course, the computers are much better now, so it's a lot easier to do it now than it was then. Back in those days, there was no Windows. It was all DOS. You had to learn all the keystrokes,
right,
all that sort of thing. But once you learned the basic stuff, you could do the instructions that way.
Your Honor, you're in your third decade as a neutral doing private dispute resolution. What are some of the most valuable things you've learned from 18 years on the bench and 23 years of ADR that you'd like our listeners to know?
The most valuable things I've learned. Well, I would say that one of the things that you never lost your case doing is making it too clear for the decider. And okay. Sometimes we'll get some briefs in and they're kind of long and they're kind of convoluted and they're going down a lot of rabbit trails and they're not real clear. They don't seem to be real clear. And then you fast forward till 3 weeks later after having worked with this brief for a long time. Now you realize that the case is not all that complicated and could have been presented in a much easier format and a much easier method. And when you make something that's not complicated, you're just creating a chance to snatch defeat from the jaws of victory. So one of the things I would say is don't make it too complicated and more complicated than it needs to be.
Oh, it's a great tip. That's a great tip.
I can attest to that as just serving as appellate counsel. When I get hired by the client after a jury verdict, usually I get the fire hose of all of the evidence that was so great for my case and the jury disregarded it and yada yada yada. And I think, okay, I need to get the thumbnail version of this. Let me go to I'm going to get the transcript and go to the opening statement or the closing argument or the trial brief and see. Hopefully the able trial attorney was able to make it nice and simple. And sometimes they're able and sometimes they're not. Sometimes they're all over the place, or the critical issue is not covered there. It's if the critical issue is, but what are the damages, or there was all the damages, but what is the liability? Usually the weakest part of the case gets glossed over, and maybe that's for a reason.
I think sometimes it's a bit of economics involved. It's like that aphorism. Some famous person once said that he wrote a long letter and finished off by saying it would have been shorter if I had more time.
That's right.
And I think that it's just economics. It's easy to sit down and start typing and just type until you're done and then send it to the arbitrator, as opposed to refining it like you do with your appellate briefs, and then try to streamline it and target it before you send it over. Maybe the money's just not there to spend doing that. And so it is what it is.
That's right. I think that's true of a lot of practice. My office just got served with a couple hundred special interrogatories, and I asked my associate to whom I assigned the project of responding to them, are they contention interrogatories or are they actually targeted interrogatories? That the idea being, and he said that they are contention interrogatories, and I said, oh, okay, so if they're real, they could probably come over with a cover letter stating, I would have propounded fewer interrogatories, but I didn't have the time. So I just sent it to my paralegal to create these shotgun contention interrogatories.
Hey, Your Honor, a few years ago, the Daily Journal reported in an interview with you that you had strong opinions against beginning a mediation with a group meeting of all the participants. Can you tell us a little bit about your thoughts about starting mediations with a group meeting, and what kinds of cases lend themselves to actually starting in a group meeting and which ones don't?
Well, I was a little surprised to see that they said I had a strong feeling. I don't know if I'd call it a strong feeling, but I do agree with the general idea. Back when mediation was just getting started and revving up, anybody who was becoming a mediator would go to mediation classes. You'd go to classes and have somebody teach you how to do a mediation. And all the mediation courses would tell you the first thing you do is you get everybody in a room, and then you give them a little speech about what a mediation is and what you're going to try to do. And then you'd start with a little it was almost like a therapy session. You'd turn to Joe and you'd say, now, Joe, the other side is claiming 1, 2, 3. How do you feel about that? And then Joe would tell us for a while how he feels about it. And then you'd turn over here to Sam and you'd say, Sam, how do you feel about what Joe just said? And then Sam would come up with what he just says, and it would kind of ramble around like that and bounce around the room. And sometimes they would go places that you didn't want them to go and weren't anticipating them going. So basically, I don't mean this to say that having group meetings is not valuable. It can be valuable if it's used in the right place. So what I do now is I talk with each side separately beforehand, before I decide whether I'm going to try to get them together a lot, and ask them for their opinions about whether we should get together or not, either at this point or a later point, or should we have some subset that gets together? Maybe we send out a little diplomatic team of 2 or 3 people, but we don't send the whole crowd over. I mean, so you have to kind of figure out where things are, because otherwise you may stir up animosities that you don't want to have stirred up in a mediation, because they'll get in the way of settling the case.
Right. Yeah, interesting. And yet there is some value to giving some people some catharsis at some point in terms of emotionally responding. But
well, that's a good point. I guess I should have prefaced my remarks by pointing out that most of the cases I'm handling are business and finance and insurance and business type of cases where you do have to keep the psychology in mind, but it's not the same thing as handling a family law case or a PI case, something like that.
Yeah.
I mean,
Your Honor,
take a little different approach when you have a case like that.
And during COVID, we've all been doing things via Zoom, and I assume you've been doing mediations during COVID via Zoom. I was wondering, did you find Zoom to be effective in terms of mediation? Do you intend to continue using Zoom once COVID-19 winds down?
I had my doubts about it when it was getting started, but I've been doing it for a good while now, and I find that it works pretty well, really. There are a few things that maybe need a little bit of finesse, like you have to make sure you learn how to move people around from one room to another, not get the wrong in the wrong room. And that's that sort of thing. But it works pretty well. One of the things that is true for mediation as well as an arbitration is that if you're handling a case that has a lot of documentation, so there's going to need to be a lot of looking at documents, then you need to make sure that either you set up a way to publish these documents so everybody can see what the document is, or that you've just let everybody know before the mediation begins that we may be looking at these 10 exhibits, so please have these 10 exhibits with you. So if I say I want to talk about the third paragraph in exhibit 10, you'll be able to pull that right up, and we're not on a 30-minute hunt. Where is that document in Omaha?
Right. Good point. Good point.
Justice Zebrowski, how do you avoid doomed mediations? I've seen mediations start, for example, with the parties opening offers just galaxies apart, I think this will never settle. This is a waste of everyone's time. And yet you come out with a settlement. And then I've seen other mediations where the parties there's a gap in the middle, but it seems bridgeable, and yet no one moves throughout the entire mediation, and it's a bust. Have you been able to pick up any clues or signs that you've learned to look out for that tell you whether a case is likely to settle, or these parties are just intractable, they're never going to move?
Well, you have to remember that most cases, the statistics show most cases still do settle, even if they don't settle at that first time you tried to mediate it. So there can be a sensible reason for having a mediation, even if you think the chances for settlement are not good right now, because it'll move it in the direction of settlement and may get the right kind of thinking started. So it's not like if the case hasn't settled today that it's a failure, because the case is probably going to settle between now and the time that the case goes to trial, and it may be because of what you got started during the mediation. So you have to keep an upbeat attitude toward it and see how much progress you can make. So I always try to make, even if I can see that I'm not going to be able to make enough progress to bring the case to a complete resolution, I try to make as much progress as possible, so that the next time we talk, if we do talk again, which we try to do, we're starting from a better plateau to get a settlement done.
Are there any other impediments to a settlement? Are there personalities? I wonder if you've encountered a situation where you think that a party could be brought to a settlement posture, but maybe that party's counsel is just still obsessed with beating his chest and staking out a principle. I wonder if you've ever come across that, and if there is a solution for that sort of problem.
That happens not infrequently. You have to try to analyze the it's sort of like departing from the strictly logical and starting to analyze the psychological now, and figure out, well, who's stopping this case from settling when it looks like it probably should settle? And then you have to just find graceful ways of getting people apart from each other, so you can talk to somebody separately. Sometimes getting two people from one side of the case and one from the other side, and getting them apart from the others. Now, you can't do that in a way that is going to antagonize the attorneys or make the attorneys think you're just trying to go around them or something like that, because they're in charge of one half of the case, and if they get their heels dug in, they're probably going to stay that way. So it's a little bit of a less as quantifiable value to try to start thinking about what somebody's psychology is, but sometimes that's what gets the case settled or doesn't.
Right. Let's talk about your memories and experience from the bench. Can you tell us some fond memories looking back at your 4 years on the Court of Appeal?
Well, that was a good experience all the way through. I had 3 good people that I was working with, and we also would bring in pro tems from time to time, and they were all very helpful. And I can't remember ever having an argument the entire time that I was on the Court of Appeal with the people I was there with. And it's not because we didn't disagree, because at times we would disagree and people would write dissents and so forth, but nobody would start calling each other names and things like that in the dissent, pointing out how stupid they are and that sort of thing. It was all done very respectfully, and I thought it was a very positive experience.
Okay, now moving to the other end of the spectrum, what was the hardest thing about being an appellate justice? Something that when you decided to retire, you thought, well, at least I'm not going to miss that part of being an appellate justice.
Well, I don't know if this fits in your parameters exactly, but one of the things about being on the Court of Appeal is, at least when I was there, caseload has always changed, and you have to know the current situation with caseload. And I haven't talked to anybody up there for a while now about what their caseloads are like. But when I was on the Court of Appeal, the caseloads were such that you could easily work 24/7, never stop working until you collapsed. I mean, there was always more things that could be read, more time that could be spent on a case. So you always had to be determining when is the time to shut off work on this case and move to the next case. And then we were talking earlier about the reason why cases are unpublished. There's an example for you. The case is unpublished because we have the answer, but we're only talking about whether it's clear enough to be publishable, and we don't have the time to decide that, so we're just going to not publish it and decide it for this case and let the case go forward.
Got it. What about the oral argument aspect of being an appellate justice? Was that I've heard from other justices that it's a particularly grueling part of the job because you really have to you've already read everything, but now you have to be prepared for what counsel is going to say during the argument, and prepare to ask questions. Did you find that a taxing part of the job?
I didn't really, because it always seemed to me that the amount of time that the appellate counsel got to argue their appellate case in the state courts, at least, was really quite small, really quite short. I mean, it's rare for anybody to get more than 30 minutes. You might get some division of 30 minutes. But that was just a culture that you didn't really have these long arguments, and most of the work got done back in chambers when you were studying the briefs.
And how useful did you find oral argument? Did you find that you had already typically gotten a pretty good sense of the issues and the facts from the briefs, and the oral argument was maybe ceremonial? Of course, you listen, but or did you feel that it was something vital that maybe counsel was just not able to get their the real gist of the case off of the page? They were buried in the minutia, and oral argument was the time for them to really shine forth with their brightest arguments.
Well, I find that sometimes it's one of one side and one of the other. The calendar would usually include some cases that after you spent a good bit of time studying the brief and talking to your colleagues about it and having conferences and then reading the underlying cases, by the time the argument was coming up, you were going to go and politely listen, but you probably have your mind pretty much made up. But at the same time, on that same calendar, there may be a couple of other cases where you really want to hear what the argument is on a particular issue. The ones that get a little bit frustrating is where, because of the short amount of time allotted to the counsel comes prepared to talk about subject A, when what you really want to talk about is subject B. And so occasionally I've seen panels send out a letter saying, please talk about this subject. And I think that's a very good practice if you can induce the justices to do that, because then at least you'll be targeting what it is that they want to hear about.
What's the secret to inducing a justice to send out a focus letter before argument?
Well, you send them a very polite letter. I'm not sure what else you can do.
Interesting. Your Honor, if we have listeners who are getting ready to appear before you in a mediation or an arbitration, what are one or two things you would want them to know about you or the way you conduct proceedings in order to get the most out of time in front of you, either on a mediation or an arbitration?
Well, there are a few things, I guess. One is that my orientation toward the mediation is not necessarily to figure out what the right answer is, but rather to figure out how can we settle this case under these circumstances.
Right. Interesting.
So a lot of times the attorneys will think we're trying to refine the law and find out what the real outcome should be if the case were litigated. But I'll tell people sometimes, I agree that you should win on argument A, but I'm telling you should pay money to settle the case anyway. Because you might not win, and if you don't win, things could get bad. It's going to cost you a lot of money. There are a lot of other things that go into it, and it's not. You don't always want to fight a scorched earth battle to the final conclusion.
Now, Justice Zebrowski, in an interview you did some years back with the California Legacy Project, you said of Court of Appeal opinions that when they're done well, it produces a good body of law that will be beneficial to the public, but that when judicial opinions are done badly, they can cause problems. And I wondered what you meant by an appellate opinion that is done badly. What are maybe some signs that you would look at to conclude that an appellate opinion is done badly, or maybe I'll ask a better question: that what kind of problems does maybe a poorly written or poorly decided appellate decision cause?
Well, I guess a good example would be that Liz Pendens case that we discussed earlier, because you get now anomalies in the law where things are not consistent. So what happens next? Now, the next justice comes down the road and sees that things are not consistent, but they've got a fork in the road. They can go to the right or they can go to the left because things are inconsistent. So some of them may decide to go to the right and some may decide to go to the left. They come to another fork in the road where things are hit another inconsistency. So it just builds on itself and builds on itself until we have this large body of jurisprudence that is just fouled up. And it's an outlier, and it's causing everybody a lot of injustice and extra expense and frustration and so forth.
Now, in the Justice Zebrowski, in the 20 years since you left the bench, have you spotted any things in the legal profession that have changed, whether on the bench or in the practice of law, or both?
It seems to me that young attorneys don't get nurtured as much as they used to. They don't get trained as much as they used to. It's more of seems like it's, at least among some of the larger firms, it seems to be almost a more Spartan approach. Come out with your shield or on it, but we're not going to train you before you go. Just go out there and fight the battle, and if you come back, great. If not, that's the way it goes. And,
do you have any advice or hopes that you'd like to impart to legal practitioners and judges?
Well, I think there's a value in this mentoring, and if they, now I understand there are economic considerations as well, but if you can afford the mentoring time, it's a valuable thing to have.
All right, very good. Well, I think that about wraps up my questions. Justice Zebrowski, are there any other words of wisdom that you'd like to impart to our audience today?
Just that when you come to your mediation, you should not necessarily have the mindset of being ready for combat, because you shouldn't view it as combat. You should view it as a chance to use a problem-solving methodology to try to get yourself a better result than you could get by fighting it out to the bitter end. Yeah,
it's a different skill set, isn't it, than winning at trial, participating in a mediation. I think you have to put down some of your arms and be prepared to come to a compromise.
And you put down your sword and bring your ears.
Right.
All right. Well, that wraps up this episode. We want to thank Casetext for sponsoring our podcast. Each week, we include links to the cases we discuss using Casetext, and listeners of the podcast can find a 25% discount available to them if they sign up at casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@calpodcast.com. And in our upcoming episodes, look for more tips on how to lay the groundwork for an appeal when preparing for trial. We once again thanks our guest today, Justice John Zebrowski. Thanks.
Yes.
Thanks again, Justice.
Thank you
Thanks so much.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.